Welcome back to the deep dive. Today we're getting our hands dirty with some intellectual property law. Specifically, we're looking at agriculture innovation and the brand new South African Plant Breeders' Rights Act, Act 12 of 2018. Our mission today: simple. We want to break down this pretty dense piece of legislation, what it does, why it matters, and how it actually works in practice. Whether you're, cramming for law exams or just curious about how we protect new plants while keeping food accessible, we'll try and cut through the jargon for you.
Yeah, and this act is a really big deal. It's been in the works, ascended back in 2019, but it only kicks in June 1st, 2025. And it completely scraps the old 1976 Act and all its fiddly amendments. Think of it as a total system reboot for plant IP in South Africa. One single consolidated rulebook now.
Okay, a reboot. And the core idea, the heart of it, is giving exclusive rights to the breeder of a new plant variety, right?
Exactly.
And breeders can mean a few things.
That's right. It could be the person who actually bred or discovered the variety, or maybe their employer if it was part of their job, or even someone who inherits or buys the rights later. They get the control.
They get the monopoly. Okay, so how do you actually get that monopoly? What's the test?
Well, that's Section 15. It sets out the big hurdle. You can potentially get a plant breeder's, right, a PBR, for pretty much any kind of plant if it passes a strict test. It has to be new, distinct, uniform, and stable. We call that the DUS criteria. Plus, it needs an acceptable name, a denomination.
DUS. Okay, that sounds technical. Is that the main filter?
It really is. It's the international standard. And yeah, failing the DUS test is probably the most common reason an application wouldn't make it. It demands real technical proof.
Okay, let's break DUS down then. Newness, what does that mean here? Section 15, 2A, I think.
Correct. So new basically means it hasn't been commercialized too early. There's a grace period. The propagating material, seeds, cuttings, whatever, or even harvested material like the fruit, can't have been sold or really disposed of commercially for more than 1 year inside South Africa before you file your application.
Only 1 year locally. That seems tight.
It is, but internationally, they give you a bit more leeway.
Okay, like for exporting or testing markets elsewhere.
Exactly. For vines and trees, which obviously take longer, you get 6 years outside South Africa. For everything else, it's 4 years internationally. If you sell it before those deadlines, sorry, it's not considered new anymore, game over for the PBR on that one.
Right. So you can test the waters, but you've got to be quick about filing if it looks promising.
Okay, what about the other letters? DUS. Quickly run us through those.
Sure. Distinct means just that it has to be clearly different, distinguishable from any other plant variety that's already known. Common knowledge. It's direct comparison.
So not just a tiny, insignificant difference. Precisely. Then uniform. This means plants of the variety need to be, well, uniform, sufficiently similar, allowing for the kind of natural variation you'd expect for how it's propagated. If you plant a field, they should look pretty much the same.
Makes sense. And stable.
Stable means those key characteristics, the distinctness, the uniformity they have to stick around. They need to remain unchanged after you propagate it again and again. So the seeds next year, take cuttings, whatever, you should get the same plant with the same features. Reliability.
Predictability. Got it. Okay, so you jump through the DUS hoops, you get your PBR certificate. How long does that protection actually last? You mentioned it varies.
It does. Section 8 covers this. It's not a single fixed term like some patents. Depending on the specific type of plant, the PBR lasts for 20, 25, or even 30 years. That's counted from the date the certificate is actually issued.
30 years? Wow. Why so long for some?
Well, think about breeding a new type of apple tree or a forestry tree. The R&D and the time to market is incredibly long. The Act recognizes that longer investment cycle.
Right, okay. So that sets the foundation.
Yeah.
Now let's talk about the scope of these rights. Section 7 sounds pretty sweeping. It gives the holder the sole right to do a whole list of things. This is where the market control comes in, isn't it?
Absolutely. This is the real power of the PBR.
Yeah.
The holder controls production or reproduction, basically, making more plants. They control offering it for sale, the actual selling, the marketing, exporting, importing, even stocking it for any of those purposes.
So the whole commercial chain.
Pretty much.
Sure.
And it even includes conditioning for propagation. That's things like cleaning seeds, drying them, sorting, packaging them up to be planted.
So they don't just control who sells the final seed packet, but who even prepares it.
Exactly. It gives them control quite far up the supply chain. It's comprehensive.
And I read somewhere that this protection isn't just about the seeds or the cuttings. It can extend further to the harvested stuff.
Yes, that's a key point in Section 7 too. The right covers the harvested material, the actual grain, fruit, flowers, whatever, if that material came from the unauthorized use of the protected propagating material.
Ah, so if someone illegally plants your protected wheat, you have rights over the grain they harvest from it.
Precisely. The law follows the product to stop people profiting from infringement indirectly.
That is clever. And what about playing around with the genetics? Making small changes. Does the Act cover that? I think you mentioned EDVs.
Yes. Essentially derived varieties. That's Section 7.3. This is really important. It stops someone taking your protected rows, say, making one tiny genetic tweak to change the shade slightly, and then claiming it's a totally new variety to avoid your PBR. If a new variety is predominantly derived from your protected one, keeps its essential characteristics, even if it's technically distinct, they still need your authorization.
So it protects the core invention against minor copycatting.
Exactly. It maintains the value of the original breeding effort.
Okay, the scope is clearly massive. Long duration, control over the whole chain, even derived varieties. If I were a small farmer hearing this, I might be a bit worried about access. Are there exceptions? Safety valves.
Yes, and they're vital. Section 10 lays out the key exceptions to the PBR holder's rights. There are some big ones. First, anything done privately and non-commercially is fine. Growing it in your own backyard for yourself, not infringement.
Okay, personal use is safe.
Right. Second, acts done for experimental purposes. Research is okay.
Good for science.
Third, and this is huge for continued innovation, acts done for breeding other different varieties. You can use a protected variety as a starting point to breed something genuinely new.
Ah, so it doesn't lock up the gene pool entirely?
Not entirely, unless your new variety ends up being an EDV, an essentially derived variety. Then you're back to needing authorization.
Okay, that makes sense. And the fourth exception, the big one for farmer.
The farmer's privilege. This is crucial, especially in a country like South Africa. It basically allows farmers to reuse protected seed or propagating material they've harvested on their own farm under certain conditions.
Under certain conditions, so it's not a free-for-all.
No. The Act says this privilege must be used according to prescribed regulations, and those regulations have to safeguard the breeder's legitimate interests. So farmers might still need to pay royalties, perhaps follow labeling rules, but the principle is they can, to some extent, save and reuse seed.
It's a balancing act, then, protecting the farmer's ability to farm and ensuring the breeder still gets rewarded.
It's a very important social and economic policy tool built right into the IP law, finding that balance. And one more thing related to scope before we move on Section 11, exhaustion of rights.
Exhaustion, meaning the rights run out.
Sort of. Once the PBR holder or someone they've authorized sells the material, say, a bag of protected seeds within South Africa, the holder's PBR rights over that specific material are generally exhausted. They can't control subsequent resales of that same bag of seed within the country.
Ah, so I buy the seed, I can sell that unopened bag to my neighbor without infringing.
Generally, yes. And these are important, but the rights are not exhausted if the next step involves further propagation. Meaning, if you buy that bag of seed and then use it to grow more seed to sell commercially yourself, that's not covered by exhaustion. That's still infringement because it involves reproduction.
Okay, so exhaustion applies to resale, not reproduction.
Correct. And the other exception is if the material is exported for propagation to a country that doesn't protect that specific type of plant variety.
Why that rule?
To stop South Africa becoming a sort of back door where people buy protected material cheaply and then ship it off to multiply it in a country with no PBR laws, undercutting the breeder internationally.
Right, closing another potential loophole. Okay, let's shift gears slightly. Who manages all this? Applications? Granting rights?
That's all handled centrally by the Registrar of Plant Breeders' Rights.
Right.
They maintain the official register, which is the definitive public record of all granted PBRs. It's all in Chapter 2.
And the application process itself. Section 16, you said it was demanding.
It is. You need detailed technical questionnaires about the variety, proving the DUS criteria. You have to pay fees. And importantly, if the applicant isn't based in South Africa, they absolutely must use a registered agent within the country to handle the application.
Makes sense for jurisdiction and grounds for rejection, besides failing DUS.
Well, Section 19 mentions things like misrepresentation lying on the application, or if the applicant just can't come up with an acceptable name, the denomination, for the variety.
Okay, but let's talk about a really interesting power baked into this act, compulsory licensing. Sections 35 and 36. This sounds like a major check on the breeder's power.
It absolutely is. It's arguably one of the most significant public interest safeguards in the entire Act.
Mhm.
It means that even if someone holds a PBR, they can't necessarily just lock the variety away or charge extortionate prices indefinitely if it's really needed.
So who can apply for one, and when?
Any person can apply to the registrar for a compulsory license. The grounds are basically that the PBR holder is unreasonably refusing to grant a voluntary license, or they're imposing really unreasonable conditions on a license.
And the registrar must issue one under certain conditions. What are they?
Yes, the registrar is obliged to grant a compulsory license if it's shown, firstly, that granting it is in the public interest. That's a broad but powerful term. And secondly, if the reasonable requirements of the public for that variety aren't being met. Maybe there aren't enough seeds available, or the price is prohibitively high, preventing access to something important.
Public interest and reasonable requirements. That sounds like it could cover things like food security crises, right?
Potentially, yes. The law is designed to have that flexibility, and when the registrar does grant a compulsory license, they set the terms. The Act specifically says they must ensure the propagating material becomes available to the public at reasonable prices.
But the original breeder isn't just cut out, are they?
No, not at all. The registrar also has to ensure the terms allow the PBR holder to still derive a reasonable advantage from their PBR. They should get fair compensation, equitable remuneration.
Right.
It's trying to force access while still respecting the innovation.
Threading the needle, as you said. Okay, so what if someone just ignores the PBR entirely? What counts as infringement, legally speaking, under Section 32?
Well, the obvious things. Doing any of those acts reserved for the holder in Section 7 without permission.
Yeah.
So unauthorized production, sale, import, export conditioning.
Yeah.
It also explicitly includes unauthorized commercial use of an essentially derived variety, an EDV,
Right.
and misuse of the variety's official name, the denomination. You can't sell the protected variety using a different name, nor can you slap the official name onto some other plant variety to try and pass it off.
Okay, pretty clear lines. And if you cross them,
Yeah.
what are the penalties? Section 55, I believe.
They are serious. The Act treats infringement as a criminal offense. If you're convicted of doing something that falls under the breeder's exclusive rights in Section 7, the penalty can be a substantial fine or even imprisonment for up to 10 years.
10 years, that's significant. That puts it on par with some pretty serious crimes.
It certainly signals how seriously the law takes these intellectual property rights in the agricultural sector. There are lesser penalties for other offenses too, like lying on applications or obstructing the registrar fines or jail time up to 2 or 4 years, potentially more for repeat offenses.
Okay, so rights are granted, they have scope, exceptions, enforcement. How do they end? Apart from just running out of time after 20, 25, or 30 years.
Right, expiration is one way. A holder can also voluntarily surrender their PBR under Section 39, but the registrar can also actively cancel a PBR. That's covered in Chapter 10, specifically Section 38.
On what grounds can the registrar cancel it?
Several key reasons. If it turns out the original DUS criteria are no longer being met, maybe the variety has lost its stability or uniformity over time, or if the holder simply fails to pay the required annual renewal fees. Basic maintenance.
Makes sense.
Also, critically, if the holder fails to provide the registrar with the necessary propagating material or information when requested, basically, if they fail to maintain the variety properly as required by Section 31.
So you have an ongoing obligation to maintain the thing you've protected.
Exactly. And if a PBR is canceled or surrendered, the consequence is final. Section 38.5 and 39.2 state the variety then automatically vests in the public domain.
Meaning anyone can use it?
Anyone. And, crucially, it cannot be re-registered under this Act ever again. Once it's public, it stays public.
Okay, so wrapping this all up, what's the big picture for you, the listener? This Plant Breeders' Rights Act, Act 12 of 2018, it's clearly a very modern, very comprehensive system. It offers really strong, long-lasting protection, potentially up to 30 years, for innovators who develop these new, distinct, stable plant varieties. That's designed to encourage investment in agricultural R&D.
But, and this is the crucial but, it's not just about the rights holder. The Act deliberately builds in those public interest safeguards. Things like the exceptions for private use, research, further breeding, the vital farmer's privilege, and that ultimate backstop compulsory licensing. It's designed as a balance.
And there's oversight too, right? It's not just the registrar acting alone.
Correct. The Act sets up an appeal board under Section 42 so you can challenge the registrar's decisions. There's also an advisory committee, Section 45, providing technical and legal advice. And transparency is key important information, like granted rights and applications, gets published in the official plant variety journal, Section 40, so everyone can see what's happening.
Okay, so a system with checks and balances. Which leads us to our final thought for you to ponder. We talked about compulsory licenses being granted based on public interest and reasonable requirements of the public. Given the increasing pressures we see globally, think climate change impacting crop yields, potential food shortages in certain regions, how might those pressures reshape what we consider to be the reasonable requirements of the public in the future?
Hmm.
Could we see that compulsory licensing provision being used more assertively if basic food security comes under serious threat? How does that calculation between incentivizing innovation and ensuring access shift when the stakes get really high?
That's definitely something worth thinking about. How flexible will that public interest test prove to be?
Something to chew on. Thanks for joining us on The Deep Dive.